Silence, court rise.
Yes, Mr. Lloyd.
My Lord, can I start with section 36 itself and the words? Since we're going to be opening UB Tiger, it may be most convenient to see it from where it's cited in UB Tiger, which is tab 12 in bundle 1. Bundle 1 is the bundle with all of the authorities for the UB Tiger issue. So it's tab 12, page 424 of volume 2297 of the report.
Yes.
And one might first note, just in passing, paragraph 18, there's a reference there to section 5 of the Limitation Act, which is, of course, contract. We're not concerned with that here, but we're dealing with section 2, which is a materially identical term, say that it refers to an action founded on torts, shall not be brought up with the expiration, etc. Lord, section 36 is in 38, what is in 36 in the next paragraph. Section 36 makes specific provision for equitable remedy in the following terms. Following time limits under this Act, that is to say,
and it includes,
quoting it here, I'm right.
it includes actions founded on tort.
Thank you. That is A, in fact. So I shouldn't have taken the quote from here because it misses out the bit relevant to us. But it's exactly, it's A, as my Lord said, A is actions founded in tort, shall not apply to any claim for specific performance of a contract or for an injunction or for other equitable relief, except insofar as any such time limit may be applied by the court by analogy in like manner as the corresponding time limit under any enactment repealed by the Limitation Act 1939 was applied before 1st of July 1940. So the question is whether the court, this court, would have applied the Section 2 tort time limit by analogy in like manner to a claim for an injunction as the corresponding time limit was applied before 1st of July 1940. And the question is not whether one can find a case showing that the corresponding time limit was or had been applied, but it's whether it would have been so applied. The question is one of principle. I don't think that's controversial, but it's made clear that this is the test by the Court of Appeal in Cia de Seguras, which I'll come to. I won't take you to it now, but the reference is 394A, which says that in terms.
I think it would be hard put to find a case in which an injunction had been granted in the case of a tort where the breach is complete and the tort was not continuing.
Well, one would be very hard, but there are no cases on injunction at all under this section. So we are breaking completely fresh ground here in any event. So it perhaps goes to the point that I was ruminating on over the short adjournment that your Lordship put to me this morning, that what distinguishing UB Tiger on grounds that it's dealing with a different remedy is very much live here, as well as simple questions of per incuriam. This is the first case, so far as we are aware, the court's having to deal with the question of an injunction in relation to this section. Now, my Lord and Lady, the approach taken in UB Tiger to this question of principle is a simple one. If the equitable remedy sought is different from those remedies available in law, or if the facts which are necessary to support an equitable claim are different from those which would be capable of supporting a claim at law, then the time limit will not be applied by analogy. Something different about equity, therefore why should we apply time limits applying to law?
And those are two alternatives, as I read this case.
Indeed. The remedy or the facts.
Yeah.
Yes.
The Seguro case was facts.
You have to hit. Yes.
This has expanded that not only to facts but to remedy.
My Lord.
Is that right? So that's how I read it.
Lord, there are earlier cases. I'll be corrected. As I go through, I think there are earlier cases putting the facts or remedy test as well. So I'm not
Right.
I'm not sure that that was a creation for the first time in UB Tiger, but that's something I'll as we go on I'll check. But that's not where I've pitched my tent so far. There might be another point,
Right.
but it is certainly. But certainly the test is in two parts. Either if the remedy sought different from the remedies in law, or if the facts necessary to support the equitable claim are different, then no, we're not going to apply by analogy. We're not going to apply this provision, section 36(1), and you can go ahead with seeking your remedy without the Limitation Act applying. So then it will be subject only to equitable questions of late use. And for the test itself, can I go? I'll obviously need to look at the judgment in more detail, but can I go straight to paragraph 45 of the judgment, which effectively encapsulates where it gets to, where Lord Justice Morbick gets to at the very end of paragraph 45, which is a few pages on page 434. It's really the last 5 lines of this paragraph, and I'll come back to how he gets there. He says, however, in cases where the facts capable of supporting a claim for equitable relief differ from those capable of supporting a claim at law, or where the equitable remedy differs in a material respect from that available at law, there is not the same reason to deprive the court of the power to grant equitable relief in an appropriate case by adopting the statutory limitation period by analogy. And there's not the same reason to means, and I won't do it. Lord, the UB Tiger related to a claim, as your Lordship has made clear, for specific performance. In other words, it's a contract case. But Lord Justice Morbick, on the face of it, set down an approach as encapsulated in those in those 5 lines, which at least has the potential to be read as a more general approach to section 36(1), given the words he used are general and are not limited to specific performance. But it's important to bear in mind where one is going from, starting from, that UB Tiger is a case dealing with a legal claim, as here, in other words, claim based on contract, as here where we've got a claim based on breach of statutory duty or whether domestic or EU, where an equitable remedy is sought in addition to damages or instead of damages. So it's legal claim, equitable remedy. It is what it is referred to in many of the older authorities. What we'll come on to is the court's auxiliary jurisdiction, where equity is acting concurrently with or as an auxiliary to a claim in law. That is going to be an important distinction with cases which are in equity's exclusive jurisdiction. But neither UB Tiger nor the case which confronts you here today are exclusive equity jurisdiction cases. They're both equity is being sought by way of auxiliary jurisdiction. This court has recently had regard to that holding of Lord Justice Morbick, and I'm perhaps starting at the end of the chronology, but it's helpful perhaps to take this first. In a different context, in the IGE USA against HMRC case, which is at tab 16 of the bundle. Can I start there? Well, we have the same judicial dream team as in ZipFit, in fact, with Lord Justice Henderson and Milady on the panel with Lord Justice Burse in that case. And that case involved an application to amend, and the issue was whether, under section 36(1) of the Limitation Act, the 6-year limitation for claims founded on the tort of deceit applied, at least arguably because it was a pleading case, applied by analogy to a claim for equitable rescission of a contract for fraudulent representation. And UB Tiger, holding that legal limitation periods were not applicable by analogy, was held to be distinguishable in IGE, which ultimately held that legal limitation periods did apply in that case by analogy, thus refusing permission to amend. And they found it was distinguishable for two reasons. Can I take you to paragraph 74 of the judgment of Lord Justice Henderson? And what he there says is the proposition of law for which the decisions of this court in P&O Ned Lloyd is, of course, UB Tiger. UB Tiger. Is authority. Proposition of law for which that decision is authority is that the 6-year limitation period applicable to an action founded on a simple contract should not be applied by analogy to a claim for specific performance pursuant to section 36(1) of the 1980 Act, with the consequence that no period of limitation is applicable to such claims. That conclusion is of no direct application to the present case for two reasons. First, this is a case about equitable rescission for fraud, not specific performance. Secondly, this court has already held in Malloy, an old case in the Court of Appeal, that the statutory predecessor of section 2 of the 1980 Act does apply by analogy to claims for equitable rescission founded on fraudulent misrepresentation. We are bound by that decision unless HMRC can establish to the contrary. And ultimately, they find that HMRC cannot establish to the contrary and that they are bound by Malloy. But the court did go on, having found that the case was distinguishable, and that, of course, I do note the reasons that it distinguished UB Tiger in principle were very much focused on the specific performance of the remedy, as your lordship put to me. But the court does go on to consider and quote from UB Tiger in the passage at paragraph 78 to 79. And what is said there is 78, the second passage on which both sides rely, I note both sides rely, is one in which Lord Justice Morbick gave a helpful explanation of the rationale which underlies the application of the statutory limitation periods by analogy. After referring to certain authorities, they then set out the quotation from Lord Justice Morbick, ending up with the 6 to 7 lines which I've already taken the court, however, in cases where, etc. And then it is said, it seems that with the test formulated by Lord Justice Morbick at the end of that passage in mind, it seems to me that in the present case, there is no material distinction between the fact capable of supporting the claim by HMRC for damages for deceit and a claim by them to rescind the settlement agreement in equity, nor in my view does the equitable remedy differ in any material respect from that available at law. And they therefore conclude at paragraph 80, for these reasons I consider that the decision of this court in UB Tiger is properly distinguishable, and the principles stated by Lord Justice Morbick do in fact provide some significant support for GE's case. They're saying the decision is distinguishable because, of course, in UB Tiger the court found that it was not analogous. So they're saying, well, the decision is distinguishable because there it's not analogous, but in our case we think it is. But they do say that the reasoning provides some significant support for GE's case. And I wanted to deal at the outset with that reliance on it for some significant support, because it might look at first sight like a further Court of Appeal endorsement of the UB Tiger approach.
Well, it does apply the twin test in 79, doesn't he?
Indeed, it appears to, but it certainly has regard to it and says it provides material support. Yeah. It does. And that's why I need to deal with it.
And it may be interesting to see quite why the two claims are regarded as on the same lines.
My Lord,
in the former case, HMRC would have sought to recover the underpaid damages quantified by reference to assessments that would have been raised. In that case, the position, the object and purpose would be to place HMRC in a position where they could directly recover the underpaid tax by assessment. So it's a question of substance, not of form.
Look, that is right, and there is a fundamental distinction, I think, between the IGE situation and UB Tiger, because IEG was a case of equity acting in its exclusive jurisdiction. In other words, there was an equitable claim and an equitable remedy. And I'll come on to the full significance of that, of exclusive equitable jurisdiction. And therefore, whether UB Tiger was right or wrong in the test which it set out, as applied to specific performance of a contract, simply didn't arise. In other words, UB Tiger, like the situation which confronts this court, is a case of equity acting in its auxiliary or concurrent jurisdiction, as I'll come on to. So in other words, the UB Tiger test, we say, was fine for the situation which confronted the court in Cia de Seguros. The test as a statement of approach for equity's exclusive jurisdiction, and hence its reliance by both sides in IEG. That was why, in other words, the challenge which I am going to mount to UB Tiger, to this court, was not only never made in IEG, it could not have been made because it wouldn't have been relevant. Because we are saying UB Tiger, that test may be fine for the exclusive equitable jurisdiction, but it's not, it's contrary to authority and wrong to use that test for the auxiliary jurisdiction of the courts of equity. And so one can understand how in IEG it was no one challenged the application of the test because it was appropriate, it was applicable to the exclusive jurisdiction. But as I will develop to the court, it is not a test which is appropriate or consistent with authority in relation to the auxiliary jurisdiction of the court. Before I come on to the detail of UB Tiger, can I set out some preliminary submissions as to why we say UB Tiger is wrong? In the first place, we note at the outset that under the test, as propounded by Lord Justice Morbick, the statutory time limit would never apply to a claim for an injunction, because an injunction is a remedy which is available only in equity, and so the equitable remedy obviously differs in a material respect from the position at law. It will never be a counterpart remedy at law. So the tests as set out in those lines can never be fulfilled. Chitty, I'm not going to go to the passage. Chitty confirms that this is new ground. There's reference to Chitty 45, bundle 2, 45379, explains that there's no case in which the statutory limitation period has been applied by analogy to an injunction at all.
Chitty also thinks that's an excellent judgment.
It does. It does. It gives no reasoning for that epithet. Spry doesn't think it's an excellent judgment.
Spry yes.
Well, I have to accept that. Our case is that the simple no equivalent remedy in law, therefore no limitation applicable by analogy test is wrong and has been born out of a misunderstanding of the case law. Now, and we do know on the face of it that the UB Tiger test appears to be in conflict with and does violence to the language of section 36 itself. Because the language of the section expressly contemplates, at least, the statutory limitation periods may apply, by analogy, to the equitable remedy of injunctive relief, because it identifies injunctions in terms in the section. Indeed, it also identifies specific performance. So it provides that time limits shall not apply to any claims for specific performance or for an injunction or for other equitable relief, except insofar as, and then sets out the analogy test. So the section appears to contemplate that there may be cases involving those remedies which will apply by analogy. But under the approach to the section in UB Tiger, this reference to injunctions would not make any sense, because such coercive remedies being unavailable and having no counterpart in law, one would simply never be able to apply the section by analogy. It would make no sense to have even included it.
Yeah. Specific performance is most commonly encountered in land contracts, one kind and another.
Yes.
And under such a contract, the purchaser gets an equitable interest as soon as contracts are exchanged. It used to be an old stamp duty dodge that entered into a contract, went into possession, never actually completed the contract. And then you've got the sort of rule in Walsh and Lonsdale, where an agreement for lease is as good as a lease, and that all depends on specific performance.
Yes.
But in those cases, an interest passes on contract.
Lord, yes. It may be that specific performance needs to be put in a separate box for those reasons, but my point applies with full force, I say, to injunction.
Yes, no, I understand.
Also referred to in that section.
I'm just thinking that specific performance, at any rate, certainly where the purchaser was in possession, the equitable courts didn't refuse on the time grounds to enforce the contract.
No.
The contract was still completely executory at the point.
Well, Lord, quite clearly, and no one dissents from this, where certainly where one's dealing with the exclusive equitable jurisdiction, one would expect there still to be a test of equivalence. And that's in no doubt. The question is, what should happen in circumstances where we're dealing with legal right and equitable remedy? And it may be complicated by there being equitable as well as legal interests connected with land and being in possession, and therefore cases which might look at first, one can't simply say specific performance contract, therefore we're dealing with auxiliary jurisdiction. Maybe that often the old cases have to be decoded, and obviously one sees in the authorities a great difficulty, but it may be that some of those examples to which your lordship has in mind are explicable because we're actually dealing, at least in part, with the exclusive jurisdiction.
Although, in any case of contract, there will be rights at law.
Lord, yes, there will be, but there may be supervening equitable
There may be equitable
rights as
well.
Yes.
In a case concerning land.
Yes.
But specific performance, as my lord says, is generally found in the context of land, but it's not absolutely limited to land.
No, quite clearly.
A few cases, for example, chattels or other interests, proprietary interests, where damages would not be an adequate remedy, and therefore SP would be granted by a court of equity.
Indeed. As an equitable remedy in respect of a legal right. Well, I accept that, and those are cases where we do say that UB Tiger has adopted the wrong approach. But we may not need to say this because it's outside the confines of this case. When this case began, there was a specific performance claim looming large. That has now gone, so I can cut the anchor to specific performance more than I perhaps could have done at an earlier stage.
Well, it may be that one can leave open the question of whether there are specific performance cases to which the Limitation Act would be applied by analogy.
Indeed.
Or would have been applied by analogy and therefore would still be applied.
Lord, yes.
Albeit that there are clearly other specific performance cases to which it would not be applied.
So how did the Court of Appeal in UB Tiger reach the position that this was the test, which on the face of it looks certainly for injunctions to create some difficulties for understanding the reference to injunctions in Cert 36.1? We say that it's based on a misunderstanding and a misinterpretation of the earlier authorities, and in particular, more recently, Obvia de Seguros in the Court of Appeal, which was, we fully accept, cited and considered in UB Tiger. It wasn't a case of simply not knowing about it. It's easier to understand how we say the reasoning in UB Tiger went wrong by looking first at Spry, if I may take you there first, which in an earlier edition was cited and was purported to be followed in UB Tiger, but which explains in its most recent edition why UB Tiger has in fact reasoned on the basis of a fundamental misunderstanding. So in terms of where we're going, Lord, if I may, I was proposing first to take the court to Spry, which explains the fundamental distinction between the auxiliary and the exclusive jurisdictions of equity. Secondly, I was going to go to Obvia de Seguros, which correctly, we say, acknowledged and applied that distinction. And then I was going to go to the reasoning and approach in UB Tiger and why we say it failed to follow that approach, despite, and of course this is important, despite Lord Justice Morbick believing that he was following the approach of Spry and Cesar Seguros. It wasn't that he disagreed with them and struck out separately. So
And at some point you're going to deal with a situation where Court of Appeal decides A, Court of Appeal then explains A in B. Is not Court of Appeal C bound by B's explanation of A?
My Lord, I will say that doesn't arise because Lord Justice Morbick did not believe that he was departing from Cesar Seguros or explain it in a wrong way. It's a case of misapplication of the test. I will come at the end back to the Young and Bristol aeroplane criteria, which I need to. But I think it might help if I take you through what we say is wrong with.
No, that's fine. You just need to deal with
it. It is firmly in my mind, my Lord. So, Lord Spry in the Authorities Bundle 1 is in tab 19 of the first volume of Authorities. And can I take you to two passages? They're both unavoidably a little long, and maybe I can just give you the passages to read rather than wearying you with me reading them all out. The first passage, which is the first in the bundle in tab 19, starting on page 601, under the heading Statutes of Limitation. This section goes through to 603, and this, as you can see from the heading on page 602, is in the section on specific performance of contracts. The next section is going to be on injunctions. This section is on specific performance. It's not directly applicable here, but it's important to see the whole picture. So could I ask you to read, starting on 601, possibly you can skip the passage on 602 from about 6 lines down in the first complete paragraph. Support for this approach can be found in the Authorities. Well, it doesn't really need all of that review from there onto the end of the first paragraph on the next page. If I could ask you to read the passage on either side of that section. And your Lordship will have seen that the footnote to the recent decision of the Court of Appeal on page 253 is a reference to UB Tiger, which it says appears to have been incorrect. And
you'd adopt the last sentence as good moral.
I'm sorry, I didn't hear that.
Adopt the last sentence of that passage, where legal rights have been barred, etc. Good moral.
Where legal rights, such as contractual or tortious rights, have been barred, is not desirable, contrary to principle indeed, that barring be circumvented by the grant of an auxiliary equitable remedies, such as specific performance or injunction.
Yes.
Indeed, we rely on that. And the next section is dealing more specifically with injunctions. And this is also a slightly long passage, but and I apologise, this was not on our reading list, and it should have been beforehand. This starts on page 606 under a similar heading, Statute of Limitations, and it goes all the way through to top of 610. And if the court's willing, it might be easier to read it to yourselves.
How far do you want us to read, Mr. Herbert?
Up to 610.
610.
610 at the top of the page.
Yeah.
The end of the first paragraph, end of that few lines.
What you get out of this is that in this case, we are acting, quote, in obedience, unquote, rather than, quote, by analogy, unquote. That's the point you're driving at.
That's the term. That's where I'm driving towards.
Yeah.
Well, can I seek to extract a slightly fuller set of propositions from those passages? First, as already indicated in relation to IGE, there are different jurisdictions of the courts of equity, or in modern terms, the court when exercising its equitable jurisdiction. There is firstly equity's auxiliary or concurrent jurisdiction, where an equitable remedy is sought in the protection of a legal right. See that on page 608, third line of the second paragraph. Is what we're dealing with in this case, statutory duty and injunction. And secondly, there's equity's exclusive jurisdiction, where an equitable remedy is sought in protection of an equitable right. And we'll come on in a moment to see that very distinction recognised in Ciudad Seguros. Secondly, Spry sets out the approach to statutory limitation periods, which applies in the case of each jurisdiction separately. Auxiliary on the one hand and exclusive on the other hand. In the case of equity's concurrent or auxiliary jurisdiction, where it's acting to enforce legal rights, then where the legal right is unenforceable by reason of the time limit, then equity will act in obedience to the time limit. Your Lordship already has the point, but I'm taking it step by step. In obedience to the time limit, because there are no rights at law in play. That's subject to obedience to the time limit. We've just read the passage, but that's the passage at 606 to the end of the first paragraph, 607. And it is important to note that Spry does not say that the inobedience jurisdiction is an absolute rule, except when the statute actually says it applies to the equitable remedy. Obviously, that's the most extreme case of inobedience, is where the statute actually says actually applies to the equitable remedy. Obviously not applicable here. But in other exclusive jurisdiction cases, equity retains a discretion, as he puts it, to decide whether or not it is unjust in the particular circumstances that the plaintiff should be permitted to proceed. And it suggested that's an exceptional jurisdiction, probably only exercisable in cases of fraud. So in cases of equitable remedy sought in respect of a legal right, the time limit is applied in obedience, is applied to the equitable remedy, although the court retains the residual discretion not to apply it in exceptional cases of fraud. And thus the inobedience description, equity is obedient to the legal limitation period. Well, standing back, Spry's test is also a pretty simple one in that effect. If a legal right, then a time bar applies, even though the remedy is equitable, with the nuance of fraud cases. And that, in short, my lord, is our situation.
And you would need to say, if a legal right and only a legal right.
Lord, yes.
To cover the cases of contract.
Indeed, indeed. And we are in the only legal right situation here. Turning then to the case of equity's exclusive jurisdiction, where equity is acting to enforce equitable rights, the test is more nuanced. Not our case, but it's important to understand it because it's central, we say, to the misunderstanding that follows. And this is taken from the passage on page 609. One can't actually see the page number. It's page 434 internally, beginning thirdly. The court here is not acting in obedience to a statute which governs legal rights, because there are no rights at law in play. But the court may decide that the material equitable right is so similar to legal rights to which a limitation period is applicable that that limitation period should be applied to it also. In the latter case, the limitation period is said to be applied by analogy. One comes on to the passage where he sees that he doesn't like the phrase by analogy and says it's used in different ways. And indeed, it's used in a different way in section 36 itself. But that's the way he puts it. And he says the principles that govern cases of this kind are that if there is a sufficiently close similarity between the exclusive equitable right in question and the legal rights which the statutory provision applies, then a court of equity will ordinarily act on it by analogy, but that it will only do so if there's nothing in the particular circumstances of the case that render it unjust to do so. And I do note that he is, Spry is there identifying close similarity to the rights in question and the legal rights. He doesn't actually talk about the facts, the point your Lordship put to me earlier at this stage, but I just note that. So it's only when we're in the world of this exclusive equitable jurisdiction, i.e. when equities are acting to enforce equitable rights, that one asks whether there is a similarity between equitable rights and remedies, legal rights and remedies, which are subject to the time bar. And then third, Spry makes a point about the language of by analogy, which I failed a moment ago. He prefers to use that language only in relation to the exclusive jurisdiction cases and to use in obedience in relation to the auxiliary jurisdiction. But he does note that these terms are used in varying senses, and that indeed Section 36 of the Limitation Act itself must be using by analogy to refer to both of Spry's in obedience and auxiliary categories. Because otherwise, if it didn't, then the court would no longer be required to act in obedience as they had previously done. So on Spry's account of the law, my lord, the no equivalent remedy, therefore no application by analogy test adopted by Justice Morbeck is cannot be right. And Spry says so in terms in the first passage that we looked at, or on page 603. And the error, so Spry would say, is that one only asks about similarity or equivalence when one is considering equity's exclusive jurisdiction. One doesn't make any such inquiry in the case of the auxiliary concurrent jurisdiction where equity is acting to enforce a legal right, because there equity acts in obedience. And so Lord Justice Morbeck shouldn't have asked that question, and indeed answered it in the way he did, in the case of a specific performance of a contract, unless there was something special about the specific performance in that case. And we say, you, my lords, my lady, should not be asking that question here in a case which is a legal right, equitable remedy case. Can I turn then to Cia de Seguros? Because as Spry notes in the current edition, if you'll notice footnote 10 on page 609, which you just looked at, the passage in Spry explaining the different jurisdictions and the approach to limitation in relation to it was approved in Cia de Seguros. And this is in the tab 10 in the bundle of authority. This case concerned equity's exclusive jurisdiction. Claim was made for equitable damages for breach of fiduciary duty, as one can see from the headnotes, as well as in parallel to claims in contract and tort for damages. So there was an exclusive jurisdiction in play here. And the passage on the approach to application by analogy, the Limitation Act, begins on internal page 120, page 394 of the report. This is judgment of Lord Justice Waller.
So 120.
Yes, 120 the report, starting at letter B under the heading, would the Court of Equity have applied this statute of limitation by analogy? The whole of this section is relevant to the conclusion. But before I ask Your Lordship perhaps to again have a read of it, maybe it'd be easier for me to make submissions first on what we say one takes from.
Yeah, just tell us what the propositions are for which you cite it.
Precisely. So the case, as I say, concerns the equitable jurisdiction, claim made for equitable damages for breach of fiduciary duty. The first point is that the Court of Appeal adopts Spry's approach to section 36(1), and when the time limit will be applied by analogy within the meaning of that section. And you will see Mr. Flo, who was then counsel for the claimant, arguing at page 395 E2F that it was only in cases of concurrent or auxiliary jurisdiction and never in cases of exclusive jurisdiction that the time limit would be applied by analogy. And Lord Justice Waller says effectively in response, no, that's not what SPRY says at 395G. This distinction, this does not seem to accord with the above quotation from SPRY. And he quotes the passage from SPRY, which refers to equity in its concurrent jurisdiction acting in obedience to a statute that relates to rights at law, and equity in its equitable jurisdiction applying the time limit by analogy, where there is a similarity between equitable and legal rights. What Lord Justice Waller had before him, of course, as I've noted, was a case of the exclusive jurisdiction. So we then see him in the passage focusing on whether the reality of the equitable claim and the remedy was similar to that sought by law. So trying to answer the analogy question.
So this was a claim at law for damages, breach of contract.
But in equity.
And for negligence.
Yes.
And for breach of fiduciary duty in connection with the same relationship. So, and the claims in contract and tort were barred by sections 2 and 5. And so the question was whether the same time bar should exclude the equitable claims
Precisely.
which basically matched the legal claims.
Precisely. But in terms of
Yes, sorry, you were going to take us.
But in terms of the general approach to Section 36, Lord Justice Waller was plainly not saying that the court must always look to see if there is a similar remedy in law in order to apply the time bar to the equitable claim. It's only in the exclusive equity situation, which is already distinguished, that he embarks on that exercise. So we say Lord Justice Waller was plainly accepting the approach of SPRY, that there's a different approach required in the inobedience situation where one's in the concurrent or jurisdiction. Just that wasn't his case. So the passage really to review against that basis is the entire passage starting at 120b. The first point he deals with, the question he asks at the beginning is, would the Court of Equity have applied limitation by analogy to a claim for equitable compensation or damages or dishonest breach of fiduciary duty? So he locates it firmly in the exclusive equitable jurisdiction. And he notes the decision of the House of Lords in Knox and Guy and Lord Westbury's position. I can take this here because it may save me having to spend a long time on Knox and Guy. Quote there is, for where the remedy in equity is correspondent to the remedy at law, and the latter is subject to a limit in point of time by the statute of limitations, the Court of Equity acts by analogy to the statute and imposes on the remedy it affords the same limitation. This is the meaning of the common phrase that the Court of Equity acts by analogy to the statute of limitations. The meaning being that where the suit in equity corresponds with an action at law, which is included in the words of the statute, the Court of Equity adopts the enactment of the statute as its own rule of procedure. If any proceedings in equity be included within the words of the statute, there a Court of Equity, like a court of law, acts in obedience to the statute. So he's distinguishing acting in an analogy in an auxiliary jurisdiction to the equitable jurisdiction, although he's focusing on where the statute actually applies. And then there's a long quote from SPRY's equitable remedies, and then it might just helpful for the court to review from page 395 to the bottom of that page to G, to the first sentence of G. One doesn't need to go into that Knoxian and Lord Ashburton and all of those. So, my lord, in Cia de Seguros, what we have is a case where the Court of Appeal, which is dealing with the application of Section 36 in the context of the exclusive jurisdiction of equity, in that context, and in relation to that exclusive jurisdiction, the court applies the sufficiently similar test and assesses the case on that basis. But it also, in relation to the concurrent jurisdiction, which wasn't directly before the court, clearly says that the approach adopted by SPRI applies in that type of case. And what then happens is that in UB Tiger...
Well, they also approved Mr. Jules Scher's decision
in Disco Club,
in which he says where the Court of Equity is exercising concurrent jurisdiction, giving the same relief, statute would be applied, but even if the relief afforded by the Court of Equity was wider than that available at law, the Court of Equity would apply the statute where there was correspondence. And then he goes on to say that equity will apply the statute by analogy where the equitable remedy is being sought in support of a legal right. Justice Waller, page 124D, seems to approve that.
Indeed. Indeed. And Lord Justice Clark gives a concurring judgment, and the relevant part is on page 399, effectively between D and F. I agree with Lord Justice Waller, etc. First, he said, makes the point, cannot mean that it's necessary to find an identical case decided before 1940. That's the point I made earlier this afternoon. Section can't mean so narrowly, etc., etc. Correct approach is to identify. There's nothing further there.
Yeah.
What then happens is that in UB Tiger, Lord Justice Morbick applies the approach which governed the exclusive jurisdiction of equity to a case in which equity was acting in its concurrent jurisdiction. And we say that is what's in conflict with the general approach to Section 36 approved in Cia de Seguros. Can I turn then to UB Tiger itself and look at its reasoning? We've set out in detail in our skeleton the 7 stages of paragraph 34 of our skeleton argument. I'm not going to repeat all of that, but it is perhaps important to go through some of it. So we're back in tab 12 for the Court of Appeal. And can I start at paragraph 34, which is headed limitation by analogy. It's important to note here...
34?
Paragraph 34, my lord.
Page 49.
Oh, I'm sorry.
429.
Yes, I beg your pardon. I'm looking at the first instance decision. 34. Yes.
And it's important to note that here in paragraph 34, Lord Justice Morbick was purporting to file or seeking to find and apply a general approach to Section 36. You can see this in paragraph 34, in which his lordship says that there were no direct authorities relating to specific performance, so he has to consider the general principle. This is potentially significant because it supports our case that there is a clear conflict between Cia de Seguros and UB Tiger. He wasn't simply looking at a particular stream of cases on specific performance. To find the general principle, we then see paragraphs 35 to 37. I'm not going to go through the detail, but he considers various authorities, including Knox and Guy, but all of the cases considered in these paragraphs do, in fact, concern equity's exclusive jurisdiction. None of them concern the auxiliary jurisdiction. So we see an action for legal and equitable account of profits, which was Knox and Guy. That's the Covent Garden Opera burning down case. We see a constructive trust, Paragon, finance. And on the basis of these, he concludes at paragraph 38 that the authorities supported the conclusion that if a statutory limitation provision, properly interpreted, applies to the claim under consideration, equity will apply in obedience to the statute, as indeed it must. However, even if the limitation period does not apply, because the claim is for an exclusively equitable remedy, the court will nonetheless apply it by analogy if the remedy is correspondent to the remedy at law. In other words, where the suit in equity corresponds with an action at law, Court of Equity adopts the statutory rule as its own rule of procedure.
And you don't quarrel with that?
No, precisely. So far we have no difficulties with the conclusion. It's all consistent with the approach taken in the equitable jurisdiction cases. Yes. But then one reaches Sia de Seguros at paragraph 39. And that's with great respect where things start to go wrong. Because if you look briefly at paragraphs 39 and 40, you can see that Lord Justice Morbick is noting that Sia approved the approach in Spry, having referred to the speeches of Westbury and Knox and Guy in Spry, then quoting Lord Justice Waller and indeed Jules Scher in QC in Coulthard Disco Club Mix. But he apparently doesn't pick up on the difference between the concurrent and the exclusive jurisdictions, which was considered and Spry's approach approved in Sia. And so at paragraph 43, he gets to the end of his consideration of Sia. Now I invite you to read, let me read to court that paragraph, the first part of that paragraph. It's not surprising that equity should apply by analogy the limitation periods applicable to claims at law for an account and for damages, breach of duty, whether in contract or tort, to claims for an account and for equitable compensation. In each case, the same facts give rise to a claim, whether at law or in equity, and the same kind of relief is obtainable. A claim for specific performance raises different considerations, however, because both relief comparable to that available from the courts of equity were not available from the common law courts, and because the facts needed to support a claim for specific performance are not in all respects the same as those necessary to support a claim for breach of a contract. Yes. So he says that City was not a surprising case because equity and law are giving the same remedies there on the basis of the same facts. But he says he has a different case before him because there is no comparable relief in law to specific performance. And that is where things go wrong, because Lord Justice Morbick doesn't realise that Sia has endorsed a different approach to the concurrent jurisdiction from that which applied in the equitable jurisdiction. And since UB Tiger involves a concurrent jurisdiction, on the face of it, specific performance being sought in aid of a legal right in a contract, it's not appropriate to address and then apply the exclusive jurisdiction by analogy test based on comparability. He should be in the territory of acting in obedience. And yet, when one goes forward to paragraph 45, one can see that Lord Justice Morbick considers that he is applying the approach in Sia and Knox. He talks about an article of Professor Beatson, some of the older case law, which is very difficult. He notes that article finds dicta in many of the older cases which are capable of supporting different conclusions on this question. And Professor Beatson, a very scholarly article, goes through a considerable number of very old authorities. But he says, in the end, I do not think it is necessary to look further than the decisions to which I have already referred in order to reach a satisfactory answer. Knox and Guy, Coulthard, and Sia de Seguros. All cases in which, etc., etc. All cases in which the facts capable of supporting a claim for equitable relief differ from those capable of supporting a claim at law, or where the equitable remedy differs in a material respect from that available at law. In those cases, there is not the same reason to deprive the court of the power to grant equitable relief in an appropriate case by adopting the statutory limitation period by analogy. And here we are. This is the test which I took you to at the beginning of my analysis, which we then reach at that point. And we can clearly see here, he takes the view that this is the test which comes from Sia, but transplanted to a different area.
Yeah. And Justice Coleman went wrong, he says, is that he considered the absence of similarity in remedies was no significance.
Yes. 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 And it's also noticeable, just to complete that picture, that not only is Lord Justice Morbick purporting to adopt the approach in Sia, which adopts Spry, but he also expressly purports to adopt Spry's approach in paragraph 48. So there he said, quite apart from these considerations, however, whatever may be said about the undesirability of allowing claim for specific performance to be brought more than 6 years after a breach of contract has occurred, the absence of a corresponding legal remedy makes it impossible, in my view, to say that the remedy in equity is correspondent to the remedy at law, or that the suit in equity corresponds with an action at law. It's also worth noting, he says, that the passage in Spry, to which Mr. Justice Coleman referred, the judge below, and which was cited with approval by this court in Sia de Seguros, does not support the conclusion that the application of a limitation period by analogy ousted the discretion of the court to grant a remedy where the circumstances would make it unjust to withhold it. And he cites a long passage on cases of injustice. But we say that overlooks the
But you say, I thought, that the passage that Justice Morbick refers to is dealing with equitable rights, not legal rights.
Precisely. So it's a further illustration that this is based on a misunderstanding. It's going to support my per curiam submission, because it is simply a misunderstanding. The wrong bit has been transplanted. So what we have ultimately is Lord Justice Morbick finding the general principle and stating it, but doing so in a way which is in conflict to the general approach to Section 36, the doctrine of the cases and the commentary, and in conflict with the very cases and academic articles on which he is considers that he is relying. Not a question in any sense of him deciding to strike out on a different line or to take a different approach or modify the approach. It's quite clear that he believes that he is citing these authorities in support of his approach and indeed relying on them. That's where his approach comes from. But they are what one can see, being transplanted from the exclusive jurisdiction wrongly. He's not saying, I consider that the exclusive jurisdiction should apply to this different category as well, it's changing the law on inobedience. We respectfully say that he hasn't appreciated that this is a different category to which there is different authority applying, indeed the very authorities on which he thought he was relying. And that's why we say there is a conflict between Sia and UB Tiger, either falling within the first Bristol aeroplane exception, and this court should correct it in favour of Sia. But one can also say simply, with respect, that Lord Justice Morbick's decision is per curiam, because it is clear from the analysis which I've taken you to that the learned judge didn't decide consciously to distinguish Sia or follow it for some other reason, but just simply misunderstood the distinction between the two categories of equitable remedy and inadvertently applied the exclusive category to a case involving the auxiliary jurisdiction. But of course, to the extent that you accept that there is a conflict, I should perhaps address you on why the conflict should be resolved in favour of Sia rather than UB Tiger. First, obviously, simply because UB Tiger was purporting to apply Sia and was not endorsing a different test. And at the end of 34, I've really taken you to that passage where the judge noted that there was no case governing the position in relation to specific performance and was reaching to the more general test to guide him to resolve the issue.
I mean, your point that you made at the beginning of this part of the appeal was that you shouldn't be able to keep a tort claim alive forever simply by asking for an injunction.
Well, indeed, that's what I'm really winding up to. It is a short way of putting it. The fact that it really stark, in fact, in a case like this, where it's not just that it goes back 44 years, but because there is no equivalent remedy, and the judge doesn't appear to have appreciated this, there will never be a case, an injunction case, where one is going to be able to apply Section 36 by analogy, despite the fact of injunction actually being mentioned in the section and therefore in the contemplation of the legislature as a remedy which it could be applied to.
The other point about specific performance is that you will, I was going to say only ever, but that's perhaps too strong, ask for specific performance of an executory contract. Once the contract's been completed, there's no need for any specific performance. Here they're asking for an injunction in respect of a tort, which, if you're right on the other issues, the breach is complete, the damage is complete, the legal remedy is barred.
Indeed.
So everything's over.
Indeed, indeed, and it has it makes it the most stark case imaginable. And I'll come on in a moment to one submission which is made by my learned friend about, as it were, the different purpose in relation to seeking the injunctive relief as opposed to damages. But we say that there's nothing in that, and that one really can see that by barring the by not applying the Limitation Act, one is allowing a claim forward to go forward, which is clearly of complete analysis. I mean, not only on the facts is it utterly analogous, exactly the same facts drive the same relief without any difference, but the conceptual purpose, the conceptual what comes out of the case, there's nothing to be put between them either. The object is to enforce the statutory duty in the same way as one might seek compensation for breach of the statutory duty.
Yeah.
And we do say that there would be anomalous and unacceptable consequences if the statutory time bar could be evaded simply by tacking on a claim for injunctive relief. Then automatically, in obedience to law approach would be overthrown in this way, and in any case pleading injunctive relief, one's past the limitation period. And the judge at first instance in UB Tigers, Lord picked up, Lord Justice Coleman explained, we say rightly, that he considered it implausible that adding a claim for, in that case, specific performance could evade the time bar, because the function of the remedy, when it is claimed in addition to damages, is simply to put an end to the accumulation of loss. This is a case where one's dealing well in the territory of specific performance in relation to a contract. So he said, well, I can't see that it's implausible that you'd allow such a claim to go forward. Similarly, Spry explains that it's for a similar reason that equity generally takes the approach of applying the time bar when in its concurrent jurisdiction. You'll note it's back on page 603, last sentence before the heading clean hands. I think it's the sentence that Lord took me to, where legal rights, such as contractual or tortious rights, have been barred, it's not desirable and is contrary to principle.
Sorry, what are you reading from now? Spry. We're back to Spry.
We're back on Spry. It's picking up page 603, the last sentence of the paragraph that my Lord Timothy Lloyd, I think, put me to as the epitome of my submission. On 603. Undesirable and contrary to principle that the barring be circumvented by the grant of auxiliary equitable remedies, such as specific performance or injunction.
Yeah.
Your legal right is barred by the fact you can't, you're out of time, and yet you tack on a claim for an injunction, and suddenly you're back in the game, to put it colloquially. Of course, it's all subject to laches, but everyone knows that laches is a slippery thing and is not the equivalent of a legal limitation period.
Yeah.
This second reason, the Spry reason, Lord Justice Morbick did consider it in UB Tiger, and maybe in a sense I should take you to paragraph 45. He noted part of the way down the anomaly, sort of letter D. He noted the anomaly. He said, which he accepted would be even more anomalous and unacceptable in the modern world, of the limitation period not applying in the situation where the relief was identical in law and equity, and presumably the necessary facts as well. But he apparently didn't see any similar concerns. At least he says there is not the same reason about applying the time bar to an equitable remedy where there's no correspondent legal remedy. He didn't actually say there was no anomaly. He just didn't say it wasn't the same reason. But with respect, we say that the anomaly and the undermining of the statutory time bar in respect of a legal right is also a problem in a case where there's no equivalent legal remedy. Because as we've explained, it's particularly in a case where there is no equivalent legal remedy, like as such an injunction, that it means that any claim framed in injunctive terms gets through. It will automatically survive the barring of the damages claim, however much the two may have a completely common basis and be attempting the same thing. And this was part of what Mr. Justice Coleman and Sprye and others took to be anomalous and unacceptable.
Of course, there wouldn't be very many claims in tort in which an injunction claim 6 years on could plausibly be asserted at all. And in that respect, this case is unusual. You say it's not plausibly asserted anyway, but I mean, the injunction sought being an order for the delivery of the tax invoices.
Yes, I accept that.
Which is not an ordinary remedy in tort.
No, we would heartily agree that it's not an ordinary remedy in tort, but it arises here, and it is a significant situation. It leaves my clients effectively completely exposed to a claim going back 44 years in respect of facts and the nature of the claim, which is entirely the same as the claim which the court has found to be time barred in law. There's one other small point I should just deal with. Paragraph 47, Lord Justice Morbick, if one looks at it from moreover onwards. Moreover, since a claim for specific performance may be made as soon as the contract has been entered into, it is very arguable that, if the limitation period were to be applied by analogy, it would be necessary to regard the cause of action as accruing at that moment, with the unfortunate result that the claim could become time-barred before any need for relief had arisen. This lends further support to the conclusion that the application of the limitation period by analogy is not appropriate in relation to claims for specific performance. We've addressed this in paragraph 47 about our skeleton. In the first place, we don't accept that is an accurate statement of the position. The need for relief could arise before breach of the duty or after it. But in the former case, where it arises before the breach of the duty, since there's been no breach, the cause of action in contract simply won't be running. It will not have accrued, and time won't be running.
It's like a true
by time. Indeed. And that precisely, the objection doesn't apply to claims for an injunction anyway, in relation to which a breach is required for equity to intervene, save in the quiet timid situation.
I think if you look at Hasham and Zina, a lot of it turns on the purchaser's equitable interest in the land.
Mm.
Yes. Well, I accept that. But I'm not going to anticipate learned friend's arguments to too great a degree, but can I deal with a few points that he has raised in response in his skeleton arguments? Lord, learned friend has not engaged with the substance of the misunderstanding or what we say is the error in the approach of Lord Justice Morbick at all. The first cluster of points they make is in relation to the Bristol aeroplane exceptions. They say that we can't rely on inconsistency with the prior decision of the House of Lords. We accept that. We don't need to go there. They say in relation to grounds 3 and 4 that we can't contend that UB Tiger is per incuriam, section 36, and Redgrave and Hurd, because that provision in that case was cited in UB Tiger. But we do say that the threshold for contending that the decision was per incuriam has been reached. We've demonstrated what, if we are right, was a misunderstanding of the difference between the test applicable to the exclusive and the auxiliary jurisdiction, which led to the wrong test being applied, and an outcome which has significant adverse effects on what was understood to be the position in the old case law. Malone's friend makes the point that Redgrave and Hurd is referred to in UB Tiger. But even if I leave that case to one side, the other case which we refer to in ground 4, Firth and Slingsby, was not referred to by Lord Justice Morbick, and it is bang on point as a case of specific performance being refused, a case where we say we see the proper approach to the auxiliary jurisdiction. I'm not going to go through that case in detail, but it might be worth just showing it very shortly. It's in tab 4. I find this rather difficult to read, I'm afraid. This was a case for specific performance of an agreement to execute a legal mortgage, and the court refused to grant specific performance. So it appears that we are in the the auxiliary jurisdiction of the court is in performance. The key passage is on page 68 of the bundle, on the halfway down, the first column, almost halfway down. It's quite hard to find about.
What authority was produced?
Therefore, at the end of 6 years, I was going to go from.
Slightly above the first whole bunch.
Yes, I'm going from slightly above the first whole bunch. Therefore, and I'll read it at the same time. Therefore, if at the end of 6 years an action had been brought either to recover the £6,000.
Sorry, I'm not with you. Where's page 69?
Page 68.
68.
Right. It's 68. First column.
Yeah.
Starting just above the first hole punch. Therefore. This is the holding.
About
Therefore,
yes,
if at the end of 6 years an action had been brought either to recover the £6,000 and interest therein mentioned, so the £6,000 interest therein mentioned, or for breach of covenant to execute a mortgage at law, the Statute of James would have been a complete bar. It seems to me quite contrary to the principles on which the Court of Equity acts, or to the way in which it obeys or follows the statute of limitations, that a remedy at law being barred, the court should decree specific performance or give effect to those stipulations. Pointed out to me this was also a claim for an account of what was due under the agreement.
To what extent does that help you on the question of precedent? Because this is Mr. Justice Sterling, which would not have bound the Court of Appeal.
You say Lord Justice Morbeck didn't consider it.
That's right.
So it was per incurium as regards this decision.
Essentially, yes. It's an additional point.
Does that work? Is it? I thought per incurium you were required to show that the court overlooked some binding authority. Maybe not.
Binding, or is it just relevant?
It's a relevant authority on point.
Yes, certainly relevant.
To him.
Is it sufficient to be relevant?
But I need to. I'll need a moment to consider that because I'll need to go back to young slower play to see whether the test is relevant. I accept it's not binding.
I thought that in the Ho case, where the previous decision of mine was rather disapproved, Lord Justice Newey said that a county court decision yes, he quotes, this is tab 15, page 331 of the report. He quotes Morell and Wakeling. The only cases in which decisions should be held to have been given per incuriam are those given in ignorance or forgetfulness of some inconsistent statutory provision or some authority binding on the court concerned.
Sorry, which paragraph is that?
22 of
Thank
the
you.
judgment. And I think at 24, Lord Justice Newey says, like four lines down, the court, that is, in which I gave the judgment, didn't know about Darini and Marker study, but that was not a decision of the Court of Appeal, Court of Coordinate Jurisdiction, House of Lords, or the Supreme Court. So, although I entirely accept that Mr. Justice Sterling's decision was relevant, not sure that you can rely on it very heavily to show that UB Tiger is pure.
I accept that on its own. I accept that on its own. I would perhaps rely on it more to build up the more general submission.
Maybe a reason why, if there is a conflict, why we should prefer Seguros to UB Tiger.
Indeed, Lord, it goes to that. It may also go to the more general jurisdiction, which is encapsulated in the Starmark Enterprises case, which Your Lordship refers to the short German. I haven't got copies at this stage for the court, but effectively we do take the case your Lordship mentioned. We only have got copies, but it's only been produced during this afternoon's submission, so I haven't had a full chance to study it. But I'm told that it is effectively the court could not apply the general principle, but it would follow the later of two conflicting decisions, where it was apparent that the latter case was wrongly decided. It's effectively what the Court of Appeal there held in that case. It may be that I should leave that for now. I can always deal with that in reply if I need to. But we do also say that the approach of UB Tiger, as you know, is very hard to reconcile with the wording of section 36(1) itself, as I've submitted. And we do also rely on that. So in any event, our primary case is that we are within the first exception for the reasons that I've mentioned, but also your lordship's point, which is that it may be appropriate, as was the case in IGC. This is a case where one can simply distinguish the approach of Lord Justice Morbick on the basis that it was enunciated in a case of specific performance, and that is the basis, after all, on which it was distinguished in that case in the results. It is not a case dealing or grappling with the issues relating to an injunction, to which, as your lordship indicated, separate principles potentially apply, and therefore didn't give and didn't purport to give full consideration to that situation. Another point which the claimants make is that they say, well, their primary concern is securing specific performance of the invoicing obligation, and that is not in correspondence to a financial claim against Royal Mail, paragraph 43. Of course, they're not speaking specific performance anymore, but I take it where they refer to specific performance, they're really talking about an injunction, and indeed a mandatory injunction. So they seek to set up an opposition between securing the performance of an invoicing obligation and a financial claim. We say that's just wrong. The claim, which is brought by the claimants, is one for damages breach of statutory duty. Abundantly clear from the pleading, sets out a claim for damages, and only a claim for an injunction further or in the alternative. It's clear also from the reality of what the claimants seek. They wish to recover the sums which they say were paid over, to Royal Mail as hidden VAT.
Right, so they want to recover it from HMRC, not Royal Mail.
They do. Well, they'd like it from us in damages if they can't get it from Royal Mail, from HMRC by way of repayment. Even if Royal Mail does provide them with an invoice, it is of course doubtful, to put it at its highest, that HMRC will oblige and simply pay out. That is of course for another day. But the claim for damages against Royal Mail is simply a more direct route of getting the payment which the claimants seek against HMRC on the back of the invoices. The claim for an injunction requiring Royal Mail to provide that invoices is simply another approach to getting what the claimants seek, which is payment of those same sums. The two are very closely bound together. There's a suggestion of the claimants that the facts supporting the claims for damages and the claims for, they say, specific performance but mean injunction are not entirely the same. Paragraph 33 of their skeleton. The distinction, in fact, is not explained, and in our submission, it's not so. On the pleadings, facts and law pleaded in support of the remedies of damages and injunction are precisely the same. The injunction claim is simply tacked on at the end of what is throughout a damages claim. For your lordship, for the court to note, Harrier amended particulars of claim, tab 23, page 280, paragraphs 40, 43, and 50. And then the injunction is sought further alternatively at paragraph 61. Then finally, Lord, I should deal shortly. The claimants have put in a supplemental skeleton without consent, in which they rely on a passage from the 1936 Law Reform Committee going back some way, but conveniently shortly before the 1939 Act, which they heavily rely on. Can I just take you? I'll wait to hear how my learned friends rely on it. But can I just take your lordships perhaps in advance to give my learned friends a preview of our response to the central paragraph, which appears to be relied on. This is in the 1936 law reform report is at tab 17 of the bundle. I'm grateful. 17 of the bundle, and it's page 557. Appears to be the important passage. Headed limitation of claims for equitable remedies. Equitable claims are in some cases directly governed by a statute of limitation, such as claims for land or rent charges. In other cases, such as specific performance.
567.
I apologize. 557. 557, my lord.
Yes.
Limitation of claims for equitable remedies. Equitable claims are in some cases directly governed by a statute of limitation, such as claims to land or rent charges. In other cases, such as specific performance or rescission on grounds of innocent misrepresentation, setting aside of gifts on the ground of undue influence, no period applies, but the plaintiff must act promptly and may be disqualified by late chiefs. In other cases where a remedy in equity corresponds to a similar remedy in law, equity follows the analogy of the statute, which applies the corresponding common law remedy, citing Knox and Guy, except that in applying equitable remedies to a case of fraud or mistake, the period of limitation is not reckoned until the fraud or mistake could with reasonable diligence have been discovered. That's not so relevant. We do not recommend any changes under this head. And that's from the end of the passage, that last sentence. The claimants say that this shows that before 1st of July 1940, which was the relevant date, the court did not apply a limitation period to claims for specific performance. And they say our appeal should therefore fail for that reason alone. Lords and Lady, there are three responses to this. First, we are concerned with injunctions. The passage has absolutely nothing to do with injunctions at all. The Law Commission doesn't say there's no case which applies time bar to an injunction, or that is the position in law. It doesn't say anything about injunctions. Secondly, the Law Commission is simply noting here that the statutory time bar, which it was considering, does not apply expressly to specific performance. The fact that a preceding Limitation Act didn't refer to specific performance doesn't tell us anything actually about the state of the law under the present Limitation Act provision, which does refer to specific performance and applies to the time limits where it was applied by analogy. The report also notes that late chiefs may be available again, but that's uncontroversial. And it also potentially ignores the hypothetical approach in SEER, which was said, what one can't simply say there's no authority applying it. The question is whether a court would have applied a time bar, not whether it did. And it's not clear that it's setting out a clear indication of what the law is. So we say that there's nothing in that report which suggests that a concurrent and exclusive distinction is a false one or is unsustainable. In fact, the report in other places reflects that distinction as a matter of principle. But we therefore say that report, even as the opinion of the Law Commission, doesn't take the position significantly any further forward. The claimants have sought to add a number of authorities to the bundle, which I'm not going to seek to take your lordships to, on the basis that they are referred to in an article by Professor Beatson, which is referred to in UB Tiger, for the propositions in relation to which they are cited by Professor Beatson. The article for your lordship to note is at paragraph 18 of the bundle. I'm not going to go to the detail of it. If I might be permitted to say to the court, I originally read my essays to Mr. Jack Beatson, and I then graduated to drafting skeleton arguments for Mr. Jack Beatson QC, and then had to file skeleton arguments before the judge. But I'm now back to Professor Jack Beatson, dealing with another capacity. But the article is a learned and scholarly analysis of conflicting authorities on these issues, going back a very long way. He says in opening 587, the authorities are conflicting and have been interpreted differently from the commentators. The article was considered by by Lord Justice Morbuck in New Tiger, and what he said is that effectively didn't help him very much and wasn't significantly relied on. It's paragraphs 44 to 45.
I think he said you could find dicta going either way.
Effectively, indeed. He said there's such a divergence of views among the commentators. Many of the older cases are capable of supporting different conclusions on the question. And he said, instead, I'm going to ground myself on the recent authorities, Sear, Knox, Spy, effectively. And that's what he... So there's no sense in which one can say that he was relying on that older conflicting case law to drive his decision in any way. He effectively put it to one side. And I, therefore, respectfully said that I can legitimately put it to one side without taking this court on a huge trail through multitudinous early authorities, because that's not the basis on which any of the modern decisions with which you were concerned have considered the issue.
Yeah.
So, Lord, unless I can assist you further, those are my submissions on UB Tiger.
Thank you very much, Mr. Handler. Yes, Mr. Cordano.
My Lord, if I could just deal with one or two small matters, because if I don't now, I will forget them. One is, we thought it might be helpful, but it sounds as though we're too late, to have Hasham and Zainab in the bundle. My Lord has already referred to it. It is available, and I would simply propose that it be added at a convenient moment. It's simply because it comes up in many of the judgments. And so we will place that at the court's disposal. I have no specific submission to make about it. So that's that. The second point to make is that the context, just to say something about the context of the duty, because we spent a lot of time looking at the regulations, but we are at a higher plane, as it were. You've seen it. But we are here looking at the European duty, which I took you to. It's the provisions which we may or may not need to open around. I think it might be helpful just for a moment to go back to the principal VAT directive and to look at the familiar, briefly, the familiar provisions, but from a different angle. And by the familiar provisions, I mean legislation bundle, divider 40, and specifically, just to retract slightly, to page 189. And I have to tread a slightly, quite a difficult line, because what I'm actually addressing is the content of the provisions, which has not been decided and will not need to be decided, and will be before the first instance judge in October. So we're in the position of deciding on an interaction between a remedy, which is a UK-based remedy, which is a mandatory injunction, and an overarching EU.
So just to be clear, you're not saying there is an EU remedy which corresponds to some kind of coercive order?
Not at all. This is purely, I say British rather than English, but it's a purely, this is an English court of law, so let's stick to this stuff.
Yeah.
But it's a purely English, and it doesn't get any more English than the debate we're having. So there's no EU remedy.
So you've got an EU right to enforce the directive.
Yes.
Against the post office, against Royal Mail directly.
Yes.
On the ground that it's an emanation of the state.
Yes.
But that doesn't entitle you to any particular remedy.
No.
For that, you go back to the domestic legislation and what you say about issue 1. Is that right?
No.
Or do you say stage? You don't need to worry about stage 1 because in your two stages, your first stage seems to be what you might call vertical,
Yes.
and stage 2 was horizontal.
Yes.
So on the assumption that Royal Mail is an ordinary trader, it's a stage 2 breach.
Yes.
On the assumption that Royal Mail is an emanation of the state, is it a stage 1
Yes.
breach?
It is.
Right.
So I mustn't tie the hands of my learned successors who will be arguing the case later, but we're going to have some presumptions at any rate to have the debate, particularly in view of the way my learned friend has put it, which is it's more than a cri de coeur, but it's surely something must be done about what he submits, is the anomaly. You've got a good solid common law right in tort, and this rather exotic, not his word, injunction tacked on his word, and I'll deal with that impression. But I believe it boils down to the suggestion that legal right, we've got no equitable rights in play in this case, of course, and on a legal right, its origins lie in direct effect. And the direct effect is the mechanism which both obliges, for this purpose, the emanation of the state, or the state, the British state, to see that certain outcomes occur. And those outcomes are what we'll just remind ourselves of in a few moments when we just look back at the PVD. That hopefully, at high level, is sufficient detail to enable me to respond to the way my learned friend puts it, as I've just briefly summarized. So I acknowledge directly effective right. I treat that, of course, as a right at law, not an equitable right, but any more than the rights in play in Seguros or UB Tiger were equitable rights. They weren't good, solid commercial stuff, to which I will return. But the effect of that is to interfere with the receipt and enjoyment of directly effective rights. And the question, which would be perhaps for this court, were it possible for this court to reopen this matter, would be, is that an outcome which is acceptable? We say it's not with great respect for this court, it's for the Supreme Court, if anyone, to review all of this. But even there, second point, the hands are tied by the legislative approach, particularly in Section 36, or the old Section 2, which followed in the 1939 Act, which followed, as you know, 3 years after the report of the Commission. There is a historical dimension to this question. I'm bound, although the words in the statute are, word in the statute is was, I'm bound by the fact that it's been held to mean would. So your lordships are, and the Supreme Court would be obliged to look at what would have been said in 1939, say, on this topic. So there's a reconstructive element, which I've just described. There is what I described as the cri de coeur, which I say really does need legislation and or a court not bound by any of the cases that we're discussing. But my more fundamental point is that dealing with these rights, which, as we've already acknowledged several times, is in an unusual story, given that we're dealing here with directly effective rights, one is in a particularly special category. So while I accept their legal rights, the consideration of the appropriateness of, if there's a choice, applying the case law is is not one that merits any particular angst, particularly given the availability of leges. My learned friend rather dismissed as slippery. If one has ever had to respond to those allegations, one knows, as we see from the cases, that it can be a far sterner regime than the 6 years in the statute. But since it's not pleaded, as far as we can find, it is pleaded. It's even better. Then it is pleaded. So there you go. We looked for it. I'm so sorry we couldn't find it, but that's my fault. So that's so. Just to now, if I may, with that perhaps rather too wordy preamble. So the right which it is sought to enforce, it has as an important part of it giving effect to Article 168. So 168, bundle page 189, an entitlement to deduct. That obviously meshes straight away with 178, which is the necessity in order to access 168 of holding an invoice, and then the obligations at 220 to issue that invoice. So we've got a unique combination of circumstances which come together at 220 and those earlier ones, in that at 168 and following, there is an obligation qua member state to ensure that there is an outcome. Normally, that leads to legislation and so forth. But at 220, we see that there is a direct obligation, given that the member state is also a trader in this story, to issue the invoice.
But for the purpose of this issue, we are assuming, are we not, that at law,
yes,
your remedies are all time barred. Whatever the duty, or whatever Royal Mail was supposed to have done, they haven't.
Yep.
And your opportunity to pursue a legal remedy has gone.
Beyond the 6 years.
Beyond the 6 years.
Yeah, beyond the 6 years.
Yes, indeed. Indeed.
And there's nothing inconsistent with EU law in that.
No, nothing at all. Set well in advance. There's no problem with that at all. I should have said that. Thank you. That's the position. We know that as far as 226, we know what the requirements are for that tax invoice, and essentially I think I've deployed sufficient now to have encapsulated, at least as a working proposition, the rights. What isn't deployed, as my Lord has already, I think, pointed out, is the UK level of the analysis. So we don't have the 30-day point, or we don't have discretions necessarily, unless in the autumn it is argued, for example, that this member state has a discretion to let itself off certain of these very basic requirements. But that's for another day. So I hope that I have said enough to put that into context, and we can essentially put that away. Then the second thing to do, as I've already hinted, is just to perhaps look at section. It might be helpful just to spend a moment. I know that the words are identical, and therefore it may not be necessary to open it, but just to remind ourselves that Section 2 of the 1939 Act, which I think is at divider 1, 2 sub 7, and I'm going to, given the proximity of the dates, I'm going to come in 1 second to the Law Commission report and say something about that. So we know that the Law Commission said something. My learned friends very helpfully reminded us what it is. And 3 years later, 2 sub 7 comes out. Although my learned friend obviously is right when he says there's no reference in the paragraph to injunctions, we see that 2 sub 7, which is the only thing that really matters, is aimed at both any claim for specific performance of a contract or for injunction, or catch-all for all other equitable relief. So that's clearly the focus. Whether that's an afterthought or whether, as is fairly obvious, that's exactly what the committee would have had in mind, doesn't matter. We can see the words on the page. And then the words after the comma, except insofar as any provision thereof may be applied by the court. So that's looking to the future. Well, that's looking both to the past perhaps and the future, but may is open-textured and quite permissive. By analogy in like manner, as the corresponding enactment repealed by this Act has heretofore been applied. On the face of it, that would appear to be a historical inquiry, but as has already been said, nobody can find a case where an injunction, a claim for an injunction, or indeed specific performance, something what my friend said about that mid-19th century case, in fact has been applied. Or limitation, the old 1623 Act was applied. In one sense, one could just say, well, job done. It never happened. And it may well be that that is the right answer. But the approach is more analytical, and the question is, well, would it have been applied? And I must go with that. But one starts from the proposition that there is no, and certainly no binding case in which it was ever applied. And if one then, treating with appropriate respect, treating the Law Revision Committee report, which is at divider 17, as of authorities number 1. That report, treating it as an extraordinarily timely snapshot of learning at time, and if one looks, I can't resist pointing to page 542.
Very distinguished committee.
Very distinguished. Although I haven't checked it, I suspect, or it's possible, that the secretary became later Sir John Foster, who was the Attorney General. I haven't checked that, but so we are definitely in good company here. We see on the next page at 543 the very, very broad conspectus, and they've obviously entitled section 13 limitation claims for equitable remedies, and if one comes to that page, and my learned friend has just read it, so we don't need to do that, but it opens with the reference to equitable claims, and it acknowledges obedience in my submission as that is used in the first sentence. So there is a class of equitable claims which are directly covered by some form of statute.
What would the equitable claims be that fall into that category? Claims to land, or generally speaking, claims at law? Claims to rent charges?
I'm presuming that the latter would be normally a contract or debt claim.
Yeah.
I haven't actually followed through which statutes of limitation, whether it's the 1623 Act or specific acts.
I mean, what puzzles me is the idea of equitable claims being claims to land or to rent charges, but I can see there might be some.
Well, it's a such as, so we know from the cases that both equitable damages, claims for equitable damages, we'll see this.
Strictly speaking, no such thing.
Oh dear.
Compensation.
Indeed, thank you. Money claims. And claims for an account, even if based on an equitable right, seem, at least when heard it together with common law claims of the same nature in the same case, seem to have all fallen within the limitation by...
We're not concerned with claims directly governed by any statutory limitation.
Indeed. What I've just said may be wrong in the sense that the ones I've just mentioned, peddling hard, may well not be questions of obedience at all. They may well be analogy. I assert that...
Well, I'm not sure about that. I think the committee seemed to be talking about cases directly governed. That is to say that the statute says
yes,
such and such a claim is barred after such and such a period.
Whereas my examples of accounts and compensation claims would not be those. They would be analogous, analogical cases. So, I mean, the second sentence is very clear. They say no period applies in line 5, at the end of line 5. Thereafter mentioning leches. Maybe it's helpful just to go on to the next page, because there's yet a third category.
Yes. Mr. Goddard, and what it says about, in the way of identifying those cases, those other cases, those are all exclusive jurisdiction of equity.
Specific performance, rescission.
Rescission for innocent representation.
I see.
And setting aside for undue influence.
Yes, I take my lord's point.
And then we come to the middle case.
Yes, which is my submission where we are in some...
Remedy in equity corresponds to a similar remedy in law.
Yes. And that focus, is, perhaps the second half of that sentence doesn't matter, it's fraud and mistake. So focusing on the top of page 18 of the report, what appears to divide us, and would divide us were the matter free from authority, is the difference between Mr. Justice Coleman and the Court of Appeal in UB Tiger. Mr. Justice Coleman said, well, it doesn't matter that the remedy is an equitable remedy. We have to look at its roots in straightforward commercial common law dispute about the radioactive containers, who is going to deal with them. Whereas what's said here is to focus on, quote, the remedy in equity and whether it has an analogue at law. And that, in my...
corresponds to a similar remedy in law.
Yes.
It will be a different remedy anyway. But does it correspond to a similar remedy?
Precisely. And with matters such as compensation claims, accounts, and declaratory claims, there are either identical or closely analogous or similar remedies in both systems. That the standout remedies that are different are specific performance and injunctions. So, were one dealing with tabula rasa, one would, I would be making, and maybe I have to do this anyway on well, perhaps quite centrally, not just en passant. One would be looking at the way equity has dealt with all the specific issues that come from coercive remedies of the specific performance and injunctive type. clustered with laches issues, discretionary issues which are pleaded, and so forth. My point being that just to say those remedies are peculiar to equity is a tip of an iceberg of learning and various associated requirements, which obviously have traditionally always been dealt with in courts of equity. But the point that I make and hope to make good is that if you go back to Knox and Guy, the story starts there, which was 2 claims for accounts, although there has been a strong theme of looking at, well, what are the roots of the claim? Do they lie in an equitable right or a legal right? And of course, quite rapidly you get into cases such as Seguros, where there were both legal and equitable rights in play, although ultimately they all stemmed from a legal solution. This is the and/or point. Nonetheless, the thread which is never broken is that where the remedy is a remedy in equity which does not correspond to a similar remedy in law, the limitation period is never applied, or the statutory limitation is never applied. And that is the unbroken thread which I say is really only open, if even there, to the Supreme Court to alter. It's just a small point. Well, if I can just complete on 13. They go on then to make the point that they don't recommend changes to deal with taking other people's coal, that kind of case. But they conclude by proposing that equitable rules as to discovery of the existence of causes of action be imported into statutes. That's paras 22 and 23. Nothing to do with our case. Save that, there are moments in the discussion in 22 and 23 which do, perhaps glancingly, refer to our issues. Just, if I can just direct your attention, I mean, these are slight points, but they're not unimportant. If I can direct your attention, therefore, to section 22, which starts at 569. There's on page 570, dealing with questions of the running of time. They deal in the first complete paragraph to start on the page. The question is a highly technical one. And just alongside the upper punched hole, they say there was also an intermediate type of action in which the courts of equity and the courts of law had concurrent jurisdiction. And I won't read the rest of it, but you can see what they say, and importantly, the conflict point. And in my submission, that conflict on the case law, certainly as it stood in 1936 and indeed today, really comes only where you've got a directly comparable form of relief, compensation, account, declaration. Otherwise, it's really very difficult to say that there is a conflict, other than at a very high level, which is, oh, you're coming to get some form of relief. Well, you're barred with those reliefs over there, so you should be barred for everything. That is not an analytical approach, particularly when one's dealing with direct effect. So in my submission, where they speak about concurrent jurisdiction and conflict, they have in mind really the same sort of thoughts that come out of 13 and definitely come from cases, that it's where the what the party wants to come away with is the same. It just happens to be branded equity rather than law. At which point the court says, no, we can't have that. And this has clearly been the view of the courts, probably back to the 18th century, if not before. The same passing comment can be made lower on page 570 in the second new paragraph on that page, about an inch below the lower punched hole. There is this. But in a number of cases after 1873, the argument was advanced that the provisions of the Judicature Act didn't affect actions in which the courts of law enjoyed exclusive or concurrent jurisdiction prior to that date. It seems to be clear where there is a fraudulent concealment of a cause of action based on fraud that the equitable rule will prevail at the present day, and they cite authority. But it is still an open question whether in the case of an action which was formerly only cognizable at the court of law, it's an answer to the statutes to say that although there's been no act of concealment, cause of action, nevertheless, cause of action itself is fraud. The plaintiff didn't discover the fraud until after the statutory period of limitation had expired. So I pause there. We're getting off the point, except that the exclusive and concurrent distinction point is made, and one can see from the context the level of generality at which the authors were operating. At 23, just to complete this, we see 2 lines from the bottom of page 571, exclusive cognizance of a court of law being mentioned, so that's in line, and the first new paragraph on the next page, starting, this position appears to us unsatisfactory, etc. They say the equitable rules, they say law should follow equity, and that's followed in the statute. So clearly, albeit that going back to para 13, it's very short, probably, no disrespect, wouldn't be that short today, but you can see that it's a tip of an iceberg, as you would expect, of extremely careful thought and profound knowledge. And importantly, if there had been, pushing an open door in a sense here, if there had been any pre-1936 cases which had muddied the waters or gave them a hook into what my learned friend is asking for today, it would have been mentioned. So, if I may give great credit to my learned junior, Mr. MacDonald, for having gone where Professor Beatson and the authors of Spry and many others have not gone. He found this document, and it's an extraordinarily useful document because it's a snapshot, but taken by experts of the position. And there's nothing to suggest that that position altered by 1940, unsurprisingly. So nothing there to undermine, we say, the classic position, and also, I'm not sure of its formal status as an aid to construction. It may be that we don't need to worry about it, but it's an extremely useful travaux, to use a word which is not appropriate, in terms of the context of 2.7 and now section 36. So I put that on one side. The next topic is to say, obviously we rely on Young and Bristol, but rather like my learned friend, it's perhaps better to start with, well, what is the merits position? And we say, with great respect, that Seguros and J.B. Tiger can stand together. They're not inconsistent, and they're not wrong. Perhaps just to start that process, I can just invite the court, in fact, to go back in time to Knox. My learned friend touched on Knox. One of the moments when Mr. Guy contributed to the law reports of the 19th century.
He was a litigious chap, wasn't he, Mr. Guy?
Yes. The opera business was obviously the film business of today. So that is to be found.
It rather looks as if it may have been possible to make money out of it.
Yes.
It isn't now.
That's true. so it's divided too, and Mr. Knox was used to make all sorts of investments. And he died, and things burnt down. But the detail perhaps doesn't matter. But there was the construction of the original. I'm just looking briefly at the head notes. There was the deal to invest, and the holding there at the top of page 2, page 657, I should say, not page 2, was on the true construction of the ledger between the parties. That showed that the agreement between them was confined to the old Covent Garden Theatre pre-fire, and therefore an account of profits alleged to have arisen at the Lyceum and the new Covent Garden Theatre was refused. So that was that story. Then that was a straight investment share of profits story. Then we have the £12,000, unimaginably large sum, invested in a partnership situation. And as one can see, just above the word held, K, in December 1864, Knox filed a bill against Guy for an account of profits in the partnership and what was due. It was held with the Lord Chancellor assenting that 6 years, there was a 6 years time bar. If one, I see that Mr. Jessel QC and Mr. Lindley were arguing the case, but if one moves forward to, forgive me, the speech of Lord Westbury at report page 674, and I don't propose to do more than just to read this. His Lordship, in fact, I shouldn't, as usual, one should go back a page. The bottom of 673, he says that a court of equity will not, after the lapse of 6 years, without acknowledgement, decree an account between a surviving partner and the estate of a deceased partner has been long settled by various decisions. The rule, of course, must be the same whether parties are reversed and the representative of the deceased partner is plaintiff. The general principles laid down as early as the case of Lockie and Lockie. I fear I haven't identified the date. I apologise. I should have done. Where it was held, where a court of equity assumes a concurrent jurisdiction with courts of law, no account will be given after the legal limit of 6 years if the statute be pleaded. If it could be doubted whether the executive of the deceased partner can, at common law, have an action of account against the surviving partner, the result will still be the same, because the court of equity, in affording such a remedy, giving such an account, would act by analogy to the statute of limitation. For where the remedy in equity is correspondent to the remedy in law, and the latter is subject to a limit in point of time by a statute of limitation, the court of equity acts by analogy to the statute and imposes on the remedy it affords the same limitation. This is the meaning of the common phrase that the court of equity acts by analogy to the statute of limitations, the meaning being that where the suit in equity corresponds with an action in law which is included in the statute, a court in equity adopts the enactment of the statute as its own procedure. So I break off there. But I place particular reliance on the language, the remedy in equity, for where the remedy in equity is corresponding. And coming right up to Mr. Justice Coleman.
Is there any difference between the remedy in equity and the suit in equity as the two expressions?
I was about, in my submission, it's the same thing. What one sues for, and then you finish that sentence. Usually one sues for damages, or one sues for an account. You sue for peace, is what you're asking for. There's potentially room, a little bit of room for manoeuvre, or there would have been if anyone had, in the subsequent 100 years, had expanded it, but nobody has. And that's perhaps the real point. So I stand by what I've just said, that it would appear that the remedy was the all-important thing. And if that be right, then one has, as it were, two shots from the point of view of the claimant. You either show that your right was a purely equitable right, or you show that the remedy is peculiar to equity. I'm not so sure about that first shot. I don't have that in my locker, so it doesn't matter. But if you've got a purely equitable right, but you're asking for an account or declaration or compensation, then it would seem that your equitable right may be swept into the area of analogous application of limitations, which only reinforces my point that the real point in these cases is what are you asking for? So,
could you just help on the last few lines on this page?
yes, with pleasure.
Where a court of equity framed its remedy on the basis of the common law, supplements the common law by extending the remedy to parties who cannot have an action of common law. There the court of equity acts in analogy to the statute. And it adopts the statute as a rule of procedure. What is he talking about there?
Well, I fear it's a slightly, my Lord will receive a slightly speculative answer, but I'm presuming the phrase frames its remedy upon the basis of the common law. I'm presuming, for example, and this is only a presumption, I have not researched the history of the action for an account, for example, nor have I looked at, but it's quite possible, that compensatory payments in equity were engendered, perhaps, in imitation of damages. My legal history is far, far too distant and far too rusty. But in my submission, it would be something of that kind, upon the basis of the common law. I can see an alternative reading which would indicate that on the basis of the common law might mean rights only arising at common law, but that wouldn't appear to fit with the case law, the later case law, which, unlike this case, deals with the question of injunctions. And we have to wait 100 years or so to get to those cases. So it might be thought perhaps there's an open question there. I acknowledge. Sorry that I can't give you more assistance there. So that then takes one to Seguros.
Well, if you're starting on a new topic, Mr. Cordero, perhaps that's best start tomorrow. How are we doing for time?
Fairly well. My learned friends set out his stall very clearly. I'm going to deal with Seguros, obviously UB. I may have to dip into the Beatson article, but it'll only be a dip. It'll just be a helicopter.
So how long do you think you'll be tomorrow?
I would have thought certainly no more than 2 hours, hopefully an hour and a half.
2 hours?
Yeah, max. Hour and a half if I can.
Right.
So, I mean, we might have a chance. One mustn't jinx it. I mustn't jinx it. But we might be finished by the middle, by the shorter journey.
Well, I would hope we finish by the shorter journey.
Yeah.
All right. 10:30 tomorrow.